All right, good afternoon, everyone. Excuse me. Good afternoon, I'm Angela Nwachi-Willig. I'm Dean of Boston University School of Law, and it is my enormous pleasure to welcome you to this historical moment, the inaugural Tamar Frankel Lecture. I want to begin by first thanking a number of people, all of whom made this extraordinary event possible. So first, I would like to thank BU Law alumnus and Boston University trustee, Nate Dalton, from the class of 1991, for his generosity in creating and funding this new endowed lectureship. Inspired by the profound influence that Professor Frankel had on him as a BU law student and as a professional throughout his entire career, Nate established this lectureship to celebrate Professor Frankel's trailblazing career, her lasting contributions to corporate and fiduciary law, and the enduring impact of her ideas on the principles that guide and should guide law and business today. Nate extends his regrets that he could not be here today, but as someone who deeply admires Professor Frankel and who so truly wanted to honor her, he repeatedly made it clear that it was most critical that we celebrate Tamar and honor her work and impact rather than find a day that he could be present for this inaugural lecture. He sends his warmest thanks, appreciation, and respect for the BU Law community, and of course, to Professor Frankel and her family. I also want to extend our sincerest thanks to Professor Frankel's family, particularly her son, Michael, who assisted in all aspects of finalizing this gift and idea, and her devoted husband, Ray Atkins, who I'm pleased to say is here with us today. Ray, can you stand? So thank you, Ray, Michael, and all of your family for sharing your wife and your mother and her many wisdoms with us for more than 5 decades. We are a better institution because of Tamar's contributions, and we offer our greatest thanks to all of you. I also want to take a moment to thank the events team at the law school, particularly Elizabeth Clancy and Laura Kirchner, who always do a spectacular job of hosting these events, and who, of course, made an extra point of working hard to make this very, very important event even more special. And thank you so much to Joe Graham and the incredible information services and technology team at BU Law, which is led by the incomparable Arthur Martin. So thank you for providing really stellar technological support. And of course, I must thank Professor Tamar Frankel herself. As many of you know, Professor Frankel is one of the true giants of our faculty's history. She was the first woman to earn tenure at Boston University School of Law. And she is a pioneer whose intellect, courage, and integrity transformed our law school and the study and practice of corporate law itself. Over her extraordinary career, spanning more than half a century, Professor Frankel shaped modern understandings of fiduciary duty, mutual funds, and business ethics. And in so doing, she helped to redefine what responsibility and trust mean in the corporate world. The Wall Street Journal described her as the, quote, intellectual godmother of the fiduciary law, end quote, referring to the US Department of Labor regulation that requires any person who is paid to provide investment advice on a retirement account to act in their client's best interest. And it's hard to imagine a more fitting phrase to describe Tamar. Her scholarship, rigorous, principled, and always anchored in a deep moral vision, continues to influence generations of lawyers, scholars, and policymakers. And it's no surprise that in 2013, the Institute for the Fiduciary Standard established the Frankel Fiduciary Prize in her honor to recognize individuals who have made significant contributions to the preservation and advancement of fiduciary principles in public life. the impact that Professor Frankel has had on her law school colleagues and the School of Law itself has been just as significant. For me, every day I walk into my office, I'm reminded about the bravery of Professor Frankel through a photograph that sits on my bookshelf, a picture of the BU Law faculty in 1969. On the right side of a sea of men in dark suits, including 2 men of color, clinical faculty member James W. Bailey and Assistant Dean Ern Haddad, stands Professor Tamar Frankel in a white dress, standing out, shining brightly, looking like the formidable scholar she is. I've never asked Tamar about her wardrobe choice for that faculty portrait, but in my mind, her choice of clothing was intentional. It was more than a fashion statement. From what I know from hearing directly from Tamar about those early days as the sole woman on the faculty, I know that she, despite how many of her male colleagues treated her, then refused to be small. She refused to shrink into the background, to doubt herself, and to remain quiet like so many women across society are taught and encouraged to do, even today, but particularly in 1969. In that portrait, I see Professor Frankel embracing her full strength and being unapologetically herself, a transformative scholar and teacher, a woman who, instead of choosing to conform, chose to transform a male-dominated profession. As faculty, all of us, regardless of our identity, owe Professor Frankel a huge debt of gratitude. By withstanding the pressure of being both the first and the only woman faculty member at BU Law, she forever shaped our experiences at the law school, providing a strong example for those who followed her and may have felt othered at the law school, as well as those who did not encounter those experiences. Place her office in the basement, and Professor Frankel turns adversity into productivity. In fact, I often think of Professor Frankel's strength when I'm seeking motivation to continue persevering through challenges, just as I know a lot of people in this room do. This year, Professor Frankel celebrated her 100th birthday on July 4th, an occasion made all the more meaningful by the creation of this lecture, which stands as a living reflection of her enduring legacy. Each year, the Tamar Frankel Lecture will bring to BU Law a leading scholar whose work engages with enduring themes at the heart of her scholarship: fiduciary duty, corporate responsibility, and the restoration of trust and integrity in business law, with the goal of promoting ethical leadership, accountability, and the public good. Unfortunately, Professor Frankel could not join us today, but we know that she is here with us in spirit and in our hearts. And we are taping this occasion to both preserve an important part of our history at the law school and to be able to show Professor Frankel once again just how much she is loved and admired within her academic home. Before I introduce our first speaker, I want to share some words that Professor Frankel wrote for us to share with the BU Law community. She writes, quote, "It is with deep humility and gratitude that I welcome you to the inaugural Tamar Frankel Endowed Lecture. This series reflects a lifelong pursuit to understand the structures of trust, to strengthen them through law, and to promote responsibility in those who hold power. The concepts of fiduciary duty and ethical leadership are not abstract ideals. They are foundations upon which just societies and honorable institutions are built. To Nate Dalton, whose generous spirit and principled vision made this series possible, I offer my heartfelt thanks. And to Boston University School of Law, my home for nearly 60 years, I express enduring pride in our shared mission of education, inquiry, and service. May this lecture series continue to ask the hard questions, inspire ethical action, and uphold the standards that our profession and our society must never forget," end quote. Now, before we hear from our inaugural lecturer, whom I know Professor Frankel is thrilled is giving this talk today, we will first hear from William Fairfield Warren Distinguished Professor Emerita Wendy Gordon, who has provided pre-recorded comments to be shared in honor of Tamar.
Hello, everyone. I have been given the significant honor of helping to introduce the inaugural lecture in the series of lectures endowed in honor of Tamar Frankel here at Boston University. I'm sorry I cannot be there in person today, but I hope this will convey a little of what Tamar has meant to me, to her colleagues and students here at BU, and to the larger legal, business, and digital communities. Now, to do this reintroduction, I took the opportunity of immersing myself again in various parts of her body of work. It is stunning. Let me start small with my own project, which I co-authored with Tamar. This was in 1994. We examined how courts should respond when a contractor spends more on doing and executing the requested services than he was going to receive if he'd gotten the bargain for price. Why would he spend more to complete a contract than he would earn from it? Because perhaps he wanted to build a reputation for solid work and for trustworthiness. Sometimes in the real world, the contractor who's getting the benefit of this amazing discount nevertheless decides to default, leaving the contractor who'd spent so much not only with all of this expenditure, unreimbursed perhaps, but also without a body of work with which to demonstrate his skills to others in the industry. So the question we were looking at was whether the aspiring party who provided a low-cost service in the hope of building a reputation could be able to recover some of his expenditures when the other party calls off the project. We argued in favor of a restitution rule that takes into account the efforts made by the aspiring newcomer to establish a reputation in the field. It was much later when I understood more thoroughly the connection between a contractor trying to establish his reputation and Tamar Frankel's larger ideas about the importance of trust and about how game theory shows the necessity of both cooperation and competition to make institutions work. The primary occasion of my greater understanding were her work on internet regulation, particularly the International Corporation for the Assignment of Domain Names and Numbers, ICANN, but also her Trust Conference in about 2010, where she brought from around the world thinkers about issues of trust and their role in human institutions that were pretty thrilling. BU, I don't think, has ever had any conference any more exciting intellectually than that one. As I mentioned, I have reintroduced myself to Tamar's work. On re-entering that vast domain, I was stunned. My imagination couldn't put its arms around the scope of the effects Tamar has had on world thought and institutions. Consider, for example, just the number of fields whose harvests Tamar Frankel has increased and where she has replanted seeds. Corporation law, contract and restitution law, SEC law, fiduciary law, application of game theory to the regulation of the internet. She and her work even have nicknames. One SEC staffer who I went to law school with told me that his colleagues refer to one of Tamar's treatises as their Bible. And a prominent financial journalist calls Tamar the, quote, intellectual godmother, unquote, of the fiduciary rule for investment advice. I would have thought that such a range of competencies and concerns would be well beyond the reach of any one human being. Articles about Tamar strive to trace the scope of her career and the interconnectedness of its ideas. But to do it right would take a poet or painter more skilled than I. While I could not have imagined before that an individual scholar should accomplish so much, now I can. And I know why only a series of lectures could begin to commemorate a career of such immense breadth and depth. Thank you.
Next, we'll hear from Professor Meredith Fran Miller, who was the second woman to earn tenure on the faculty
here
at
at
BU Law.
Boston University.
Thank you, Angela. Great to see so many people here interested in Tamar's work. I'm interested in Tamar. And I want to take you back half a century. And that picture that Andrew, Andrew, you have that picture. That picture was 69. I'm going to take you to 1975. 69 to 75. She was the only woman on the faculty all that time. And in 1975, I don't consider that I was on the faculty. I was a lecturer, then an instructor, then an adjunct professor, then an adjunct professor teaching you would 3 full courses, $5,000 apiece. I will tell you, I need not tell you the memory of it. But anyway, I went to the dean and said, this is not right. It is amazing you are right. And so he put me up for a tenure track. And I would say half of the faculty came to my courses, to my classes, and sat there and watched me teach. And they'd sit there and they'd go. And I won't even begin to tell you the comments I got back on my teaching.
The low-cost service.
So one day, Henry Monahan said to my husband, look, she's a cute little dancing poodle.
Calls off the project.
Classroom,
We argued in
but she
favor
makes
of
a big mistake
restitution
trying
that
to
takes
stay
into account the
states.
efforts made by the aspiring
And
newcomer
I
to
went
establish a
to
reputation in
Tamar,
the field.
and by then they moved her out of her office in the basement, not the basement of the library, those little glass boxes on the bottom floor of the library. She had to be there because the faculty floor was the second floor. And it had
Ideas about the importance of
and no women's room. There were no women's room. Anyway, there was one in the whole school.
cooperation.
And so by then she'd been moved over to the base, right up there. I don't know what's there anymore. The next floor up over there. But anyway, I went to Tamar and I told her what had been happening to me. And she looked at me for about 2 seconds, and I'm going to go over here and do it. Show
I
it,
can.
Cal. She went,
But also,
they are pygmies. They are not worthy of tying your shoelaces. And I could not go along.
and a role in
I was terrified.
pretty thrilling.
Someone grateful for being given the opportunity to be in a classroom. And she taught me what it was to fight. And I did. And I had a fight to that thick. I never used it, best domain, but goddamn, I would
My
have.
imagination.
Anyway, this is my opportunity to show my public gratitude. Consider for made my academic career possible. Harvest, I changed the world at this law school. But just look at that picture. And it used to be on the wall for as long as I was teaching here, I think. Tamar alone with all those people. And she, they didn't talk to her, but God, no.
She did her work even.
She didn't care. She put her nose down, did her work, and outshone them all. So they
Told me that his colleagues
his two subjects,
was their Bible. And
they were
financial
directly
journalists
implicated, as
called
when
Tamar the intellectual godmother,
I taught trusts and estates.
unquote, of the fiduciary rule for investment advice.
And people will think, what does it have to do with fiduciary? Healthcare is the biggest business in this country now. And think about that and all the fiduciary obligations going on. But then Dr. Casey, riddled with fiduciary responsibility. So I knew well her impact on, excuse me, that larger swath of professional behavior. And in fact, like Wendy, Tamar and I co-authored a piece probably just about the time she was co-authoring with Wendy.
Memory
Consent.
a career of such immense breadth and depth.
Did transcend barriers and break new ground, not only as a female, but as a foreigner to boot. She is one tough cookie, and that is the highest accolade I can give to anyone. Tamar, here's to you.
And now I'm thrilled to introduce the inaugural Tamar Frankel Lecturer, Professor Ann Lipton, the Laurence W. DeMuth Chair and Professor of Law at the University of Colorado Law School. Professor Lipton is a leading voice in corporate governance whose recent work explores the democratic and social dimensions of corporate power, making her the ideal scholar to launch this new tradition in Professor Frankel's honor. After earning her JD from Harvard Law School, Professor Lipton clerked for the U.S. Third Circuit Court of Appeals, Judge Edward Becker, and then U.S. Supreme Court Justice David Souter. She then practiced in New York City for over 10 years, where she specialized in plaintiff-side securities and corporate litigation at the trial and appellate levels. She also worked briefly for the Securities and Exchange Commission. Prior to joining the Colorado Law faculty, Professor Lipton taught at Tulane Law School, where she was the Michael M. Fleischman Professor in Business Law and Entrepreneurship. Her articles have appeared in the Journal of Corporation Law, the Fordham Law Review, and the Georgetown Law Journal, among other publications. Her recent article in the Harvard Law Review, "Will the Real Shareholder Primacy Please Stand Up?" I thought that was pretty funny, discusses democratic concerns around corporate power. Beginning with the 9th edition, she became one of the authors of the casebook Securities Regulations, Cases and Materials, and she also blogs regularly for the Business Law Prof blog. So please join me in giving a hearty welcome to the inaugural Tamar Frankel Lecturer, Professor Ann Lipton.
Thank you. So I want to just begin by adding my voice to the chorus of praise for Professor Frankel's work. She's a legend in the field, and I can't tell you how honored I am to have been invited to be to kick off this series. And the school advertised this lecture on LinkedIn, and the comments were just flooded with her former students praising her. And usually it was words to the effect of, "She made securitization law interesting." Which is, it's funny, but in the business law space, this is what we aspire to. Anyway, and I'll aspire to that in this talk, which is called Corporate Governance Authoritarianism, and I'll kick it off
But also
by pointing to this slide. So I've only got 2 slides, by the way. You're going to be looking at this for a while. But so this is actually from a casebook that I use when I teach business associations, and I like to show it to my students and ask them to look at it and say, what's missing? What is missing from this slide? What is missing from this slide? You can just shout it out and see all the audience participation card I've got. Shareholders, there are no shareholders on this slide. which for me is actually an illustration of one of the fundamental problems in corporate law, which is where do the shareholders go? Where do we put them? And that's what I'm talking about today. So why does this question matter? I mean, we know why it matters if you're a member of the board of directors. And we know why it matters if you hold shares. But most people aren't on corporate boards. And in America, around 40% of adults have no exposure to the stock market at all, not even indirectly, like through a mutual fund. So why does this question, where do the stockholders go, matter to everyone, whether they're a stockholder or not, whether they're on a board or not? Well,
regulation of the
a few
internet.
corporations that are household
She
names.
and her work.
Facebook, it has 3 billion users monthly globally and was one of the primary sources of the internet in parts of the world. Amazon Web Services powers 76 million websites, and not long ago it experienced a brief outage that took out Venmo, Snapchat, Roblox, and your
Of the fiduciary.
many institutions. Walmart serves 255 million customers every week, and it's the sole grocery store in many parts of the country. My point is, in our society, corporations are major sources of power. Corporate managers, whoever sits at the top of that corporate pyramid, they're going to decide how billions or trillions of dollars of capital are going to be deployed across the globe. They'll direct armies of labor provided by employees and contractors. Their resources exceed those of many governments. When corporation power is deployed in pro-social ways, fantastic innovations. We get the iPhone and cures for COVID and Reese's Oreo cookies and
could begin to commemorate a career
investors
of
earn
such
enough
immense
for a comfortable
breadth.
retirement. Employees are able
Thank
to
you.
advance in their jobs, and they send their kids to school and buy their dream house. But when that power is deployed in antisocial ways, we get cars that explode or airplanes that fall out of the sky or AI-induced psychosis. But critically, even the most pro-social corporations in the world will still leave some people better off than others. They're going to leave some people with more wealth than others, with some people with more resources than others. And ultimately, those decisions, who does well, who does poorly, those are left to corporate managers, which means everyone in society is ultimately affected by those decisions. And so the internal process for making those decisions, that's going to affect everyone, whether or not they're actually a shareholder and whether or not they're actually a board member. And so that's why it matters how these decisions are made. Well, how are these decisions made? Well, to begin, someone wants to create a corporation. They first have to get a charter from a state, any state. They can pick any state they want. Doesn't matter if any operations there. And that state's law will set the ground rules for how the board can exercise its authority. Among the 50 states, there are some variations, but the general rule is legally corporations are run by the board of directors, or in a public company, typically the board of directors oversees at a high level, and then they hire the corporate officers, the chief executive officer, the chief financial officer to run the company on a day-to-day basis. To get the ball rolling, they need investors who contribute capital, and those are the shareholders, and their money is used to finance the company's growth, to rent office space, buy equipment, hire employees. The shareholders can expect that if the company does well, they'll get some of that profit back, and that's why they invest in the first place. The board and the top officers, collectively, they're the corporate managers, and they have relatively uncabined discretion to decide how to allocate the corporation's resources, whether to build or close a plant, hire employees or lay them off, whether to pay out profits to investors or reinvest them. As a formal matter, when they make these choices, they have a duty to act with care, and they have a duty to act with loyalty, the fiduciary obligations. But as a practical matter, even if they make controversial decisions, money-losing decisions, they're immune from any kind of legal liability. That's because of a principle known as the business judgment rule. For the vast majority of corporate decisions, even if they seem unethical or short-sighted or incompetent or stupid, the business judgment rule provides that courts will not second-guess how the board chooses to run the company, and any shareholder lawsuit is doomed to fail. Now, I'm exaggerating. There are going to be some constraints. At bare minimum, the corporation will be subject to various laws that mandate or prohibit certain actions, and boards have to be concerned with profits, because if stock prices fall, at the very least, future shareholders will think twice about investing. Still, corporate boards, a relatively small handful of people, maybe 10 or 12 in the largest companies and a couple of top officers, they ultimately have an extraordinary amount of discretion to decide how other people's money is going to be used, even when those decisions have global consequences. But there's one natural source of constraint on board action, and that's the shareholders themselves. Shareholders have almost no formal authority to interfere with board decisions, but shareholders do get to vote on a very small number of corporate matters. And the most important thing they vote on is who the directors are, who the board is. The board is elected by shareholders in the first instance, and so shareholders can replace the directors who they think are not performing their jobs adequately. The power of that vote, though, is a practical matter. The ability of shareholders to, in fact, make a difference with their votes over time, that's varied at different points. The late 19th and early 20th centuries
Consider, for example,
the rise of truly giant corporations that dominated entire industries. Country-spanning companies headed by names like Rockefeller, Carnegie, J.P. Morgan. This is the Gilded Age of moguls who would later be derided as princes of property by FDR. After World War I, mom and pop investors, ordinary people, the legal term is retail investors, they poured money into public stocks. Shareholding quickly became widespread in what has been described as a great shift of corporate finance from Wall Street to Main Street. But at that time, a lot of the stock available to the public carried no votes at all. Voting shares were held only by a small group of insiders. And even when the general public held voting shares, corporate insiders were able to manipulate the votes through their power to collect proxies. Since it was infeasible for most shareholders to physically go and attend a shareholder meeting and make their voice heard, the shareholders voted by proxy, meaning they'd fill out a ballot that would be voted on by their designee at the shareholder meeting. Corporate managers were in charge of distributing these proxy ballots and collecting them, and so they had a variety of means they could use to ensure that the votes would never be cast against them. As a practical matter, then, mom and pop investors had very little say in the conduct of the companies that depended on their capital. The abysmal state of shareholder voting was actually viewed as a democratic affront at the time, prompting an outcry throughout the 1920s until the system came to a thundering crash, literally in 1929. After the crash and the Great Depression, dual-class share systems, where corporations issued high-vote shares to insiders and low-vote shares to everyone else, those fell out of favor, and they were mostly banned by the New York Stock Exchange. Congress passed the Securities Exchange Act of 1934, which, among other things, gave the Securities and Exchange Commission the power to regulate proxy voting. As one judge later put it, it was the intent of Congress to require a fair opportunity for the operation of corporate suffrage. The control of great corporations by a very few persons was the abuse at which Congress struck. But this didn't mean that shareholder power was ascendant, because even with a norm of single-class shares, so that every share carried the same number of votes, and even after curbing how insiders had exploited the proxy system, ultimately public shareholders were atomized. Each individual shareholder only had a few shares, which made it very difficult for them to organize and force management to address their concerns. Now, some shareholders made the effort. In the 30s and 40s, a shareholder activist named Lewis Gilbert campaigned to increase shareholder rights. In the 50s, women shareholders organized to try to force corporations to put women on company boards. In the 60s, Ralph Nader organized Campaign GM to persuade shareholders to vote for greater social
sometimes in the real world.
Motors. But these campaigns were largely unsuccessful. Boards viewed these corporate gadflies as annoyances, but not as real challenges to their power. But matters did not rest there. For many years, the largest corporations had been offering pension funds to their workers as part of their employment benefits. And traditionally, these funds only invested in bonds or in the stock of the company that was actually offering the plan. But in 1950, as part of a deal with the United Auto Workers, General Motors developed a new innovation. It would offer a pension plan that invested in a wide variety of corporate stocks under professional management. The notion caught on, and by 1974, pension plans held 30% of the stock in American companies. On top of that, in 1978, 401k was added to the tax code, and Section 401k encouraged employers to create retirement plans that invested a portion of employees' salaries in diversified mutual funds. The result was a de-retailization of the shareholder base, which meant ordinary mom and pop investors stopped buying individual stocks. Instead, they gained access to the market through institutional investors, pension funds, and mutual funds, which themselves invest on behalf of their beneficiaries. When the first federal securities law was passed in 1933, institutions owned less than 9% of publicly traded stock. By 1980, they held 35% of publicly traded stock, and that number was rapidly increasing. The largest institutions held blocks in multiple companies that may be 5 or 10%, and by now, by the way, the market is about 70% institutional shareholder. So these new shareholders, professionalized, wealthy, and concentrated, had pull with corporate management. Management had to listen to them. And the SEC encouraged shareholder oversight by requiring companies to start disclosing more information about director backgrounds and qualifications. Now then, in the 1980s, perhaps for the first time since the rise of the great corporations at the turn of the century, shareholders had sufficiently concentrated power to pose a real challenge to corporate boards. That power was most evident in the context of corporate takeovers. Buyout shops like KKR, Carlyle, and Blackstone would identify underperforming companies, buy up their shares, and take them over. Institutional shareholders endorsed these strategies, and so this period witnessed these epic battles between incumbent management and corporate raiders. Boards fought back by lobbying for legal protections, but because at the federal level, shareholder power had only increased over time, they instead turned to state legislatures where they were incorporated. One by one, they persuaded the state legislatures to give them fairly broad powers to block buyout shops from accumulating shares without board permission. That way, they could prevent anyone from acquiring enough shares to just vote them out and take over the company. So dissidents shifted tactics. Now, their ability to just buy up a majority of the stock, they instead would buy minority stakes, under 10%, and urge other shareholders to vote with them to install new directors. These activist attacks could be successful, again, because the investor base was increasingly concentrated among a very small number of professional investors. And the SEC helped matters along by revising its proxy rules, again, this time to make it easier for shareholders to communicate with each other. And the SEC adopted new rules that made clear institutional shareholders had a fiduciary obligation to vote their shares in their beneficiaries' interests. And they'd have to disclose what their voting policies were, make sure everyone could see them. These amendments fueled the rise of proxy advisors, firms that specialize in advising institutional shareholders on how to vote the thousands of proxies they receive every year. Proxy advisors help streamline the voting process for institutional shareholders, making them easy to consolidate around a single position. And critically, they often recommend against management. So for example, they might recommend in favor of activists who want to replace the directors, or they might recommend against a deal that the board wants to complete. And this is the part that management really dislikes, they sometimes recommend against executive pay packages. Scholars have found that proxy advisor recommendations this way or that way can influence 5 to 10% of the vote, so it's not insignificant. Now, not every dissident shareholder runs a contest to replace the board. Some shareholders seek to influence the board by sponsoring resolutions, requesting board action on particular topics, like resolve. The shareholders of company X request the board do Y. These shareholder proposals can cover all kinds of things.
Doing
like, for
and
example,
executing
used to reform corporate governance. So in a company where the director and the CEO are the same position, they might request that those positions be separated. But shareholder proposals are usually associated with attempts to make companies more socially responsible. For example, in 1951, shareholders sought a vote on whether Greyhound bus lines should desegregate the buses. In the 1960s, shareholders sought a vote on whether Dow Chemical should stop manufacturing napalm for use in the Vietnam
getting the benefit of this amazing discount.
Shareholders sought a vote on whether Cracker Barrel should stop discriminating against gay employees. But the difficulty with shareholder proposals is, from a procedural point of view, figuring out how to get them actually voted. Traditionally, a shareholder might attend the shareholder meeting and then from the floor offer a proposal for all the shareholders to vote on. But today, everything is proxy voting, meaning shareholders are so dispersed, they don't actually go to the shareholder meeting. Instead, they vote in advance by filling out a proxy ballot. So if a shareholder goes to a meeting and says, I, from the floor, offer this proposal, well, nobody's there. They're standing alone in the room. No one's going to vote on it. The SEC knows about this problem, so way back in 1940, it began to require that corporations include shareholder proposals on the proxy ballots that are circulated in advance, so that all shareholders have a chance to vote on them. But even with those rules in place, for a very long time, these proposals were not very successful. Historically, they garnered very low levels of support. Yet, once again, very recently, as the shareholder base consolidated, something shifted. Large asset managers began to support some proposals. They voted in favor of resolutions for more board diversity. They voted for boards to prepare for climate change. At Sturm Ruger, the shareholders voted for the board to report on gun safety. This relatively recent success may again be traced to the concentrated power of an institutional shareholder base, newly encouraged by the SEC to focus on their fiduciary obligations when voting their shares, and assisted in that effort by proxy advisors. So shareholder proposals have actually become a significant way for shareholders to signal discontent to corporate boards and pressure boards to change direction. Notably, the various levers of shareholder power kind of work in tandem here. Most shareholder proposals are non-binding, meaning shareholders ask for a board action, but they don't demand it, and that's because shareholders don't really have the power to force the board to do anything. The board is still tasked with running the company. So they make a request. But if boards ignore a successful shareholder proposal, then in the next election, the proxy advisor might recommend voting against particular directors, sort of in retaliation for them not what shareholders asked for. So the power of proxy advisors, coupled with the shareholder proposal mechanism, has given shareholders a lot more practical control over board decision-making than they might otherwise have had. Now, one way a board might try to escape this pressure, control the votes. During the 80s, when the boards first found themselves under attack, they pushed to lift the New York Stock Exchange ban on dual-class structures so that they could award high vote shares to their allies. They didn't succeed entirely. The New York Stock Exchange did lift its outright ban on dual-class stock, but across all the exchanges, the new rule became companies could go public initially with a dual-class share structure, but they couldn't switch to one after they were already publicly traded. That didn't help existing boards defend against contests for control in the 80s, so the matter was dormant for a while, until companies like Google and Facebook made their public debut with dual-class shares, giving their founders outsized voting power within the company. The justification for that was these tech companies needed space to invest in long-term research and development, and therefore they needed to defend against activists who just didn't understand their vision.
So much.
That kicked off a trend for tech companies, Silicon Valley companies going public while retaining founder control. Not all of them, but a lot of them: Palantir, Snap, Robinhood, Coinbase. Other companies might go public with a single class share structure, but with one or two large block holders who hold like 40% of the stock, and then they could defend against activists that way. But even that, it turned out, didn't insulate boards from shareholder challenge, largely because of Delaware. Delaware, for historical reasons, is the most popular state for incorporating public companies, and as I said, under state corporate governance law, which is usually Delaware law, boards have nearly complete discretion to make decisions about how to run their companies. Nearly complete. The big exception, especially in Delaware, comes when a board operates under a conflict of interest. When the board makes a decision that will enrich themselves at the expense of the public stockholders, at that point, if a shareholder sues, courts will apply special scrutiny to ensure that the deal is entirely fair to shareholders. Now, if the board isn't completely conflicted, like let's say only one member has a conflict, the boards can avoid that kind of judicial scrutiny if they just have the independent, unconflicted board make the decision. If an independent member of the board makes the call, if they're the final decision maker, then we go back to complete deference. But controlling shareholders are treated differently than ordinary board members. Just like with ordinary board members, if there's a controlling shareholder conflict and a shareholder sues, then that's a decision that gets special scrutiny by the Delaware courts. But unlike with board conflicts, Delaware didn't allow controlling shareholder conflicts to be cured just by putting an independent board member and have them approve it. The reason it didn't was because there was always a fear that even an ostensibly independent board member was still going to be beholden to the controlling shareholder who could just keep them out of their position. The upshot being, whenever a situation involved a controlling shareholder conflict, unlike a board-level conflict, those were being very closely policed by the Delaware courts. And over time, Delaware came to take a very broad view about what even counts as a conflict that would merit this kind of scrutiny. So, for example, recently, Facebook got in trouble with the FTC for violating users' privacy. The FTC wanted to fine Facebook and Mark Zuckerberg personally for the violations. But apparently, Facebook agreed to pay the FTC more money than the FTC had requested in exchange for letting Mark Zuckerberg off the hook. In other words, shareholder money was used to pay off the FTC to protect the controlling shareholder. That was the kind of thing a Delaware court said represented a conflict that public shareholders could sue over, and that case just settled for $190 million. And Delaware defined control very broadly. Even for minority shareholders, they could be treated as controllers, which meant that their conflicted transactions would be overseen by the Delaware courts. For example, you may have heard that the Delaware court recently invalidated Elon Musk's $56 billion pay package to Tesla. The court held that Elon Musk was a controlling shareholder of Tesla, even though he only had 20% of the shares because of all of his influence that he had over the board. So all these companies, they sought to evade shareholder pressure by going public with controlling shareholders or large blockholders, only to run smack into the Delaware judiciary, which kept upping the level of scrutiny that they were going to apply to business decisions that involved controlling shareholder conflicts. I mean, I don't want to overstate, corporate boards have had and continue to have a terrific amount of power to control corporate resources. Most shareholder lawsuits continue to fail. But between the voting power of institutional shareholders and the oversight of the Delaware judiciary, public company boards suddenly found themselves under more pressure and required to meet more demands from conflicting shareholders than ever before. That's the path we've been on since the 80s. That's the solution we've come up with to the problem we've been grappling with since the end of the 19th century. What do we do about the enormous amount of economic power wielded by a very small handful of people who control these vast corporations? The solution we settled on: create giant shareholders and empower them to push back on boards. But if the story of the past 35 years has been increasing the exercise of shareholder power, the story of the last 2 or 3 has been a rather dramatic swing in the opposite direction. Because while all this was happening in the public markets, shareholders gradually gaining more power and making more demands of boards, it was a completely different story in the private markets. As I said, in response to the '29 market crash, Congress created the federal securities laws. These laws were intended to ensure that if companies sought capital from a large number of investors, from the general public, they'd be required to make various disclosures. Beginning in the 90s, Congress and the SEC became persuaded that when a company only sold stock to sophisticated investors, like these new wealthy institutions, there's no need for disclosure. These investors can bargain with corporate managers for the information they need. So the securities laws were changed to make it far easier for companies to raise enormous amounts of capital without ever going public in the first place. Startups, once again, in the tech industry, found they could stay private indefinitely, raising all the money they needed from a handful of wealthy institutions, which meant their only disclosure obligations were whatever these investors demanded, which it turns out wasn't very much, and the information could be kept confidential from the general public. Without public trading and without public disclosure, these firms removed themselves from the pressure of public markets entirely. Well-heeled investors competed for the opportunity to invest in hot startups, and founders discovered that they could choose who they'd allow to invest. They'd choose their own investors. That meant, of course, that investors who developed a reputation for being slow or interfering with management prerogatives would be iced out, not just from one private company.
This was in 1994.
As a practical matter, then, company
Courts should respond when a contractor spends more
over their firms, and even as their companies grew larger,
requested services than he was going to receive if he got the bargain for price. Why would he spend
They're
more
incredibly important systemically. They periodically raise billions
from
of
it
dollars in investment
because
funding.
perhaps he wanted to build
They contractually restrict who their shares can be sold to, meaning the corporate managers have absolutely no fear of activist attacks.
Sometimes
No
in
one's
the
going to
real
buy
world,
up their shares and agitate for change. They don't have to worry about lawsuits in Delaware. None of the investors are going to risk getting a reputation for causing trouble. Because they operate out of the public eye and without the oversight of the court system, these massive private companies were able to develop their own governance practices. Founders and early investors, instead of just electing board members and letting boards run companies, would actually enter into contracts that gave different investors very specific rights. Like an investor might be able to approve or reject a CEO candidate, or approve or reject merger proposals, or proposals to expand the board of directors. With these shareholder agreements in place, as a practical matter, it would be the founders and the venture capital backers who would make critical decisions about how to run the company, not the board members, and certainly not the other shareholders. Many of these private companies failed, of course, but the ones that did go public, they could be wildly successful. And when they did eventually go public, they might still have these shareholder agreements in place, contracts that gave specific insiders the right to control major company decisions, regardless of what the board wanted and regardless of what the shareholders wanted. And honestly, the sense that I get is that a certain mindset was created in this private company space, a mindset that accountability only inhibits action, that building a successful firm means centralizing power in a single founder, and that any procedures that inhibit that founder's ability to act represent a drag on profit seeking, or worse, a drag on that founder's ability to effectuate their singular vision. This community of private investors, venture capital, private equity, Silicon Valley, they contributed a lot to Donald Trump's campaign. And almost immediately after his election, the federal government began rewriting the rules that limit in ways that limit shareholder rights. For example, right out of the gate, the SEC issued new guidance concerning whether large institutional investors would be deemed active or passive. It sounds technical, but it's actually really important. Investors who take large stakes in companies are categorized as either active or passive. Active means that you've invested for the purpose of influencing management. And if you're active, you're subject to an extremely onerous disclosure regime. The very largest investors, the mutual fund companies that have most of America's 401k money, they literally can't be categorized as active because they can't comply with the disclosure obligations. It would be impossible for them. They're too big. So for a very long time, the SEC treated the exercise of shareholder rights, discussing executive pay with management, discussing corporate social responsibility. The SEC treated that as something that a passive investor might do, which is how the biggest mutual funds were able to continue to engage with management. But in February of this year, after Trump took office, the SEC announced that even these kinds of engagements would transform a passive investor into an active one. Tellingly, BlackRock and Vanguard immediately scaled back their meetings with corporate management. The latest figures are like their board engagements are down 30 to 45%. In other words, the largest investors in the world are beating a retreat from overseeing their portfolio companies. But that's not all. The SEC has announced plans to limit how frequently public companies report their financial results. Ever since 1970, public companies have had to report their financial results on a quarterly basis. Now it looks like it's going to be semi-annually, meaning shareholders will get far fewer updates about corporate performance and a lot less insight into how boards are performing, which of course makes it harder for shareholders to ask them to change course. But that's not all. The Trump administration has declared what I can only call an all-out war on proxy advisors, the companies that provide this guidance to institutional shareholders. Two big companies, ISS and Glass Lewis, dominate the market for proxy advice. So they're under investigation for antitrust violations. The White House is considering forming a new executive order to limit their activities, and both ISS and Glass Lewis happen to be owned by foreign companies. The ISS is essentially owned by the German Stock Exchange, and Glass Lewis is owned by a Canadian firm. So they're being investigated as to whether they pose a threat to national security. Let me say that again. The administration is investigating whether the Canadians pose a threat to national security. But there's more. The SEC approved a new program at Exxon, which will probably become a model for other companies. Exxon was permitted to approach its retail investors, which are maybe 25% of the shareholder base, and ask them to pre-register all their proxy votes every year perpetually to always vote in favor of management. Don't get me wrong, retail investors can drop out of the program if they like. They can sign up to cast their votes with management and then stop. But the problem with retail shareholders, remember, historically has been they tend not to pay attention to corporate votes at all. That's why they've been so hard to organize. It's why shareholder influence only became significant when institutional shareholders became involved.
Because perhaps you
Exxon is
wanted
betting
to
that once
build a
retail investors
reputation.
opt into the program, they'll never opt out, so that Exxon's board can bank a significant number of votes right out of the gate in every proxy election forever. Retail investors who have other priorities, like who maybe want to oppose management on CEO before, maybe care about carbon emissions, they don't get to bank their votes forever. Only the ones who vote with management. And there's more. One significant way that we enforce the disclosure requirements of the federal securities laws is through the securities class action. Shareholders can sue when a company issues false statements that ultimately result in shareholder losses. Class actions, which group all shareholder claims together, are a critical tool because securities fraud actions are actually very expensive to litigate, so economically they only make sense to bring as a class. The SEC recently announced that it would allow companies to require that any shareholder actions be brought exclusively in private arbitration rather than a courtroom. And these private arbitrations would have to be brought by investors individually, which means that even if some small number of shareholders have claims that are worth litigating individually, and that's a big if, their claims are going to be handled privately. The public will never know the details of what was alleged or how it was resolved. But it's not clear it's legal for companies incorporated in Delaware to adopt these mandatory arbitration provisions. So Paul Atkins, the SEC chair, recently urged a group of Delaware legislators to change their law. And there's more, because Chair Atkins has also announced that he'll be limiting shareholders' ability to offer shareholder proposals for inclusion on the corporate proxy. He's already taken some administrative steps in this regard to limit the power of people to offer shareholder proposals, and he's also asked Delaware to change its law about that as well. What about Delaware, by the way? Where is Delaware? Well, remember all those companies that went public with shareholder agreements, handing individual shareholders the right to overrule corporate decisions? A couple of years ago, a Delaware court held that they violated Delaware law because of this reason Delaware law requires is that the boards be in charge of running the company. That decision angered a lot of venture capital and private equity firms who rely on shareholder agreements, and they threatened that they would just take their companies out of the state because you can incorporate in any state you want. The Delaware legislature responded within months by amending its corporate law to authorize the use of shareholder agreements to displace board governance. But the protests continued. Corporate boards and controlling shareholders insisted that Delaware law had become too constraining. So the Delaware legislature, in consultation with top Facebook executives, once again amended its law, this time to get rid of all those strict limits that have been placed on controlling shareholders. In other words, the mechanisms that enabled the rise of the institutional investor as a counterweight to insider control of our largest avatars of economic power appear to be unraveling. So that's where we are. That's where we seem to be going. That said, I want to take a step back and think about the story that I've just been telling. I'm talking about challenges to corporate boards that are instigated by shareholders, and notwithstanding things like shareholder proposals over gun safety, shareholders mostly care about money. They care about a financial return, especially institutional shareholders. So if we're worried about the kind of economic power that corporate boards wield, we may not exactly think it's a great improvement to have massive profit-seeking institutional investors push for more influence. Those takeovers in the 80s, that resulted in a lot of worker layoffs and bankruptcies. The dissident shareholders who take small stakes today, usually their plan involves voting employee pension plans.
But to do it right would take a poet.
Exactly the solution to corporate power that we've been looking for, is what I'm saying.
Well,
but what's also true is that this system creates a kind of division of authority, a separation of powers in corporate governance. Boards know they're being scrutinized and evaluated by others, and they can't begin to commemorate their own impulses. They have to make public disclosures explaining themselves to shareholders, and those disclosures aren't just available to shareholders. Now they're available to the general public, to regulators, to activists, to employees. All those different actors are given more insight into corporate operations. Judicial decisions, the kind that might be reduced if shareholder claims are shunted into private arbitration, those are obviously a mechanism of public accountability. Courts are articulating standards of board conduct, and even just the information that's revealed in a public trial, regardless of outcome, surfaces additional information about how boards operate that can then be used as a mechanism to advocate for change. It also matters, I think, if we limit private enforcement rights so that the law, like the federal securities laws, can only be enforced by state actors like the SEC. Because when only state actors have the right to sue over lawbreaking, state actors can be captured. They can choose to enforce the law only against their enemies and let the violations of their friends skate by. The state can consolidate its own power by promising a lenient enforcement regime only for those who don't offer opposition. They can't do that when private shareholders have powerful enforcement rights. That said, at this particular moment, our legal systems seem to be shifting. The ethos across the board seems to be that powerful men should not be held accountable to the public, that the public is not entitled to information about power that's being exercised, that extraordinary men should be able
Sometimes
to
in the real world, the
procedural
contractor is
constraint.
getting the benefit
In 1910, speaking of the giant corporations of the
Nevertheless,
era, Woodrow Wilson said, modern democratic society cannot afford to constitute its economic undertakings upon the monarchist or aristocratic principle. That may have been the sentiment at the end of the Gilded Age. It remains to be seen whether it still holds today. Thank you, and I look forward to
demonstrate his skills to others in the industry. So the question we were looking at was whether the aspiring party that provided the low-cost service